Glad to have you back. It is still TVC Breakfast. I will turn our attention to another story now. Ekiti State Governor Ayodele Fayose has dragged the Economic and Financial Crimes Commission, EFCC, before the Federal High Court sitting in Ado-Ekiti, challenging the freezing of his bank accounts. Now, Fayose also joined Zenith Bank in the suit and is praying the court to order the EFCC to lift its restriction on his 2 personal accounts with the bank. Now, the EFCC and Zenith Bank were not represented in court when the case opened yesterday. It has been adjourned until Monday next week.
I wish to state clearly that my election was funded 2 years ago by Zenith Bank PLC. Fundraising, donations from friends and associates, as well as sale of campaign souvenirs. I have no financial transaction whatsoever with the Office of the National Security Advisor under Colonel Sambu Dasuki retired, and former Minister of State for Defense, Senator Musli Okorie, either by cash, check, or electronic transfer. I challenge the Economic and Financial Crimes Commission to publish statements made by Senator Musli Okorie, his son, or any other associated with money from the National Security Advisor's office, where they claim they gave me money for the election.
All right, joining us in the studio is a lawyer, Emmanuel Okorie, and from our Abuja studio is a senior advocate of Nigeria, Joe Okeagi, but he's not there yet. You're welcome. It's good to have you on the show.
Thank you. Good morning.
Well, before we go on into these discussions, let's just, give, deeper insight into this case. Now, the personal accounts of Ekiti State Governor Ayodele Fayose and those of some of his associates were frozen by the EFCC, that's the Economic and Financial Crimes Commission, on June the 20th over allegations that he got monies meant for procurement of arms from the former National Security Advisor Sambu Dasuki.
Fayose has since challenged the EFCC to fight corruption within the ambit of the law, citing Section 308 of the 1999 Constitution, which grants him immunity as a sitting governor.
The EFCC, in a swift response to Fayose's assertion, stated that under the Constitution, government executives are not immune from investigation. The news of EFCC's actions since hitting the airwaves has unsettled and divided the political and legal space. While some think it is unconstitutional for the EFCC to have swooped on a sitting governor despite his immunity, those in support of the action of the anti-graft agency say the immunity clause doesn't stop anyone from being investigated.
Fayose's current travail is clearly another test of our nation's constitution and federalism.
Yes, very interesting one there. Section 308 of the 1999 Constitution, as amended, provides immunity for the president, his vice, governor, and their deputies. What do you make of this action of the EFCC?
Well, obviously, Section 308, like you have mentioned, of the Constitution, grants immunity to the president, the vice, the governor, and deputy governor. But certainly, this provision does not actually preclude the EFCC in carrying out its function, which it's currently doing. Now, what has happened is that there's a clear distinction that must be made out between the prosecution and the investigation. That's obvious, that's clear. You have to have a clear understanding that while somebody is a sitting governor, the Constitution does not preclude investigation into his account. And of course, before you can actually undertake to do such investigation, I trust that the EFCC itself would have done the necessary prerequisites to doing that. In other words, I mean that the EFCC ought to, and I suppose they have done, gone to court, maybe to get an ex parte injunction order, of the courts to be able to do what they are doing. So the EFCC has not commenced any prosecution, not to my knowledge.
Okay, so if you go by that EFCC Act, the Act is 34 Section 34 precisely,
Yes.
subsection 1.
Yes.
That's the particular act we are talking about.
Yes.
So, which of course you're talking about an ex parte motion from the bank from the
From
court
the court,
to
yes.
freeze the account.
Yes.
But how do you carry out an ex parte application without the name of the governor? Doesn't that, I don't know, I'm not a lawyer, but
No, I understand that clearly. What has actually happened is that the EFCC Act has a form. There's a form. There are two forms attached to it. There's a Form A and there's a Form B. The Form B that is attached to the EFCC Act actually lists out, how you actually take out such actions. It is not directed at the person you are investigating. It's directed to the bank where the money is traced to. So when an account, or when a bank, for instance, or money has been received into a particular account in any particular bank, and the EFCC gets an order of court to investigate such accounts, the EFCC gets that order as against the bank and serves the order on the bank requesting that such and such and such account be frozen for the purposes of investigation. So when that is done, it does not matter whoever his name is on the account. That's why the distinction between investigation and prosecution comes in.
And this is irrespective, just like you've said, whether it's a governor or president or whoever.
Very well.
But for the EFCC, now in the course of doing this investigation, and the EFCC finds out, oh, this account belongs to a sitting governor, it has to get a court order, just like she said, an ex parte, whatever, from the court. And arrest the person involved must be arrested, come before the court for his account to be frozen. Am I correct?
No, incidentally, in the investigation and prosecution are two different things. If you are in course of investigation, you find that a sitting governor is culpable, for instance, what happens is he begins to enjoy the provisions of 308 of the Constitution, which gives him immunity. So the fact that today you have investigated or you have found out that there is money which got into his account by source of some crime or the other.
Allegedly?
Yes, allegedly. It does not mean that, of course, that you cannot do anything. You can wait while he sits as governor because the immunity subsists while he's governor.
Indeed.
But the moment he steps out of his governorship office, of course, you can proceed against him.
All right.
Because, you see, because there's the period that he sits there does not count when it comes to lapse of time. So if he sits there for the next 8 years, for instance, it will mean that the day he steps out is the day, the prosecution, of course, can take over.
I'd like you to go back to, if you remember, Ganifawa case versus IGP of 2002, where there was a case of investigation, not prosecution, not freezing of an account. Is it the same? Because what Fawemi was saying that there has to do with investigation, but if an account is frozen, is it still part of investigation?
It is investigation. It is investigation. You see, that case you just referred to, Ganifawa and IGP, clearly actually stated in the Supreme Court, it clearly stated that there's a clear distinction between investigation and prosecution. So if the Supreme Court has said so, it means, look at it this way. If in the course of freezing an account or in course of investigation, and you allow the money to sit in the account with the governor, whoever the governor is in parentheses now, whoever it is, has access to the funds, it means that the governor will have operate account. By the time you actually want to prosecute, perhaps recover these funds, the money will no longer be there.
Okay.
So
now,
if you freeze the account,
is there a conflict between those two provisions? What the Constitution says, Section 1 and 2 of the Constitution, does that provision of the EFCC Act, Section 34, conflict with this Section 308? Is that where the problem is?
In my view, it does not conflict. Right. In my view, it does not conflict.
Okay, let's stay on that same 308. If you also go further, the provision of that particular section was talking about not having this criminal prosecution against us, so they are not distracted.
Civil or criminal, as a matter of fact.
So they can face the matter of governor squarely. But if a governor's account is being frozen, I don't know how the governor will not be distracted in this economy. Please, can you just share?
The obvious thing is an account will not be frozen in the first place. The investigation that will lead to freezing of an account will not actually occur in the first place if the money is not traceable to some form of crime. And so when you have monies which are illicitly gotten, which are by way of some commission of crime.
But at this point, it's still an allegation.
We don't know that.
Yes, supposedly.
So
supposedly.
you've taken the governor out of, you've not given the governor access to his own fund, and you expect him to govern. I mean, effectively, how would that work?
That's where investigation comes in. Both the EFCC and the police are professionals in their rights. And so when they're investigating this money, for instance, this account, for instance, And don't forget that no investigation is done in isolation. People will be spoken to. For instance, the bank is the person the order has been issued against, for instance.
So by the time you line up witnesses, is this part of investigation? Is it not prosecution?
No, you are not prosecuting. There are people, for instance, in the instant case, there are people, for instance, who are also, charged, or who could today, as we speak, who do not enjoy immunity. And people who can actually testify. Their cases can run.
Okay, let's look at what this particular section says. 308 subsection 1A says, and I quote, "No civil or criminal proceedings shall be instituted or continued against a person to whom this section applies during his period in office." In this case, a sitting governor, right? Now, 308, section 308(3), he cannot be arrested or prosecuted while still in office. That no mention is made of the assets of the governor of enjoying such immunity alongside him. In this case, his personal bank account. So, it means that immunity does not affect his assets. Is that what we're saying?
My attitude to this is that, in as much as I believe that the EFCC is not infringing, what they're doing is investigation. What they're doing is freezing, which is part of investigation. But my personal view on this is that there is a serious necessity for some of these things to be tried out in court. And I can bet you that that is why the governor, Fayose himself, has taken the EFCC and Zenith Bank to court, as we speak. Some of these things, for instance, every case decides what it is actually what is actually presented to it to decide. Now, if you don't also forget that there's no way you have a constitution, for instance, or you have a law that is actually able to arrest every situation. There are situations that come.
It's interesting you talk about that, but because this constitution says a sitting governor, a sitting president, or his deputy, or whoever, cannot be sued or cannot be, be brought before the court. But these persons can actually sue.
Well, yes, of course, he has. You know why he has done that?
Why is that?
Why the governor has done that is because he wants to defreeze an account that's been frozen. And that is the job of the court to decide. And interestingly, this morning, listening to your TVC news this morning, I actually heard that, of course, it's taking them to court. And that I'm sure it is by way of ex parte, and that the court has actually adjourned the matter for EFCC and Zenith Bank to come and actually say their bit about it. It is upon the EFCC furnishing what information they have that it would have enabled the court to decide if there are other things that the earlier decided cases have.
According to Michael Zokome, who is the counsel to Fayose, that the EFCC didn't get such court's order to freeze the account.
Well, that's what Mike Zokome has said. But I can bet you, or I strongly believe, my personal views, is that EFCC being a body that is seasoned and who actually knows the powers and the limit of the powers, would ordinarily not wake up, go to freeze an account, or go to Zenith Bank, for instance, and say freeze this account and that account and that account without getting a necessary.
Are you saying that has not happened before, where there are no court orders and some accounts were frozen in this country?
I'm not aware, but if it does, it will be an aberration. It will be illegal, and I will certainly not support such.
So going forward now, what do you think we should be doing with the Constitution, especially in the area of that power that is exercisable only if the person has been arrested? Fayose is protected from arrest, right?
That's right.
That's correct. But he has the power to go to court. I'm thinking, just like a layman on the street, how is it that he's protected, by the law from being arrested or from being taken to court or even from being prosecuted? But he has the power to, go to court.
It's a shield and sword affair. It's a shield and sword affair. There are certain situations that you find yourself that you actually use a shield to shield yourself. And you're not using a sword. The federal government is not using a sword here, which will mean that the federal government has taken him. In this situation, he is the one who is attacking. He is the one who is actually saying, no, you cannot do this. And so he's the one who is inviting the battle to the EFCC.
Okay, all right. According to Falano, actually said that this what some people have argued, that this case has to do with some pre-election offense, so that immunity clause doesn't cover offenses that are committed before the election. Does that sit well with you?
Incidentally, this is an interesting aspect of what we're discussing. Now, there are crimes that have been committed. There are issues of allegations, of one crime or the other that has been committed, prior to election. Now, whether you can prosecute a sitting governor for such pre-election matters before he was sworn in, for instance. There are things he did. If he had done anything, that's unconstitutional, that's illegal, prior to his being sworn in as governor, you cannot stop the EFCC or indeed the police or the Attorney General of the Federation from prosecuting him. I'll give you an example. The president himself is undergoing a trial today based on his qualifications,
yes.
And so that case is still running in Abuja as we speak. And so if the president who proud to or who has submitted his credentials is running or undergoing a trial as we speak, then there is no reason why anybody who is actually a sitting governor cannot. I'll give you another classic example. In Abia State, for instance, the governor, allegedly submitted fake tax clearance certificates prior to election. Today, as we speak, a federal high court in Abuja
has removed him.
Yes, has removed him from office. Of course, I hear that, of course, he's appealed. Now, but the point here is, what has happened is, prior to election, he was alleged to have submitted fake tax clearance certificates. Now, the opponent, or the person who came second in the primaries, had actually taken him to court. And the court has decided that he is not the governor because he was not qualified ab initio. So when you have situations like that, and if, for instance, the case in point, Fayose had committed any crimes, assuming before he became a governor, there is no law as I speak today that I'm aware of that says you cannot prosecute him for pre-election crimes.
So are we to, infer then that what the law is saying, what the law envisages is, if this crime or offense is committed within the period that he is governor or president, as it were, is that what the Constitution is saying?
That's in my view. That is what the Constitution is saying. And what it actually means is, you are governor today, you are the president today, you are the vice president, or you are the deputy governor today. As it is, we don't want any distractions. That does not preclude anything you have committed prior to becoming governor. Yes.
Okay. Let's look at Section 44, subsection 2, where the EFCC or the court is empowered to go into getting assets, freezing assets, and all that. But the subsection 1 of that same particular subsection gave us a caveat where it is mandatory to be done under some kind of court order. Can you just shed more light on that?
The court order, like I said, is the court order directed. You see, the court order cannot be gotten at once. Just anybody can go get it. No. The court order, there is already a form. There's a specified form under the EFCC Act that leads you, that guides you how to get an order.
Okay.
That order is not made out against a sitting governor. It is not made out as against the president. It is made out, in fact, specifically for banks and other financial institutions. So if you are a financial institution and money is traceable to your account, in a manner that can or has not been explained clearly, what it obviously means is that the order will be directed at somebody, and that's how we arrived at this.
Okay.
Because if Fayose today, for instance, is not a sitting governor, we won't be discussing this issue.
All right.
Because he will go for prosecution. Just like the other people, I suppose, that the FCC will doing their work. I imagine that other people who were mentioned in this debacle will, as we speak today, be heading to court, perhaps.
All right. Of course, we're still talking the legal implications of the freezing of the account of a sitting governor in the person of Ayodele Fayose, the governor of Ekiti State. Of course, that's been done by the EFCC. And so we're trying as much as we can, to look at all of this and, find out where the law really stands so that, we're better today than, this is a precedent, right? Now, what are the things that we can actually take away from this, as far as the Constitution is concerned, and indeed the, EFCC Establishment Act?
Oh, as we speak, in these areas, like I said, what we actually can take out of this is we're deepening our democracy. Some of this deepening of democracy is done by things like this. Because when you have things that you did not envisage when you were doing the act, but incidentally they come and they become realities, the best way to go is to get interpretations. But then again, that's why you also have judicial reviews. If you have situations that you had not contemplated that come on, and of course that's why the National Assembly is there anyway. And so if you have situations like this, and you choose, for instance, to say, oh, okay, because of these scenarios that we have, that we're dealing with now, that were not there previously, it will become necessary to amend this act, to add a subsection, to add a new section entirely. And so as we speak, both the Constitution, both the EFCC Act, both the political terrain, everybody will start to benefit from deepening the democracy in the manner we've said.
Okay, all right. Perhaps I can just throw in one more question. Sarab says that according to Article 30 of the UN Convention Against Corruption, where it entrenches and, of course, functions where, there's no immunities, as it were, based on that particular article, that if persons are found culpable under the same article, which Nigeria is a signatory to, and according to Section 12, if you sign international treaties and binding and all that, that every other law really should not matter. Do you agree?
Subscribe to that?
Well, it's an international convention. It's an international body. And it's difficult for you to implement it to the fullest. For instance, what we have is a peculiar case. If they say, for instance, there's no immunity anywhere, what I think they are striving is to have an international standard where nobody is seen as above the law. As a matter of fact, you know that immunity has actually been topical. It's been an issue. Whether immunity should be removed, immunity should not be removed. Some of us hold the view that there is no necessity for any immunity. If you're a governor, you should do the things that you need to do. You should not be placed above any laws, immunity or otherwise, because you're a governor, because you're a president. If you do the right things, nobody is actually coming to hold you or to actually...
But you know that even if you do the right things, there's a possibility of some people who don't like you, they just simply do not like you, and they take advantage of that opening, of that...
And that's why a governor swears in Attorney General of the state. You see, you have Attorney General of the Federation, and most of the suits that you will find, except of course the very peculiar particular ones about like certificate, you will have just the president. But otherwise, the Attorney General has a job, has a function to do. Who is level-headed, who knows what he's doing, who is focused, who is actually visionary, somebody who can actually concentrate, take his job, multitasking person. That's the kind of person you should have as a governor.
Okay.
All right, Nemek. No, not Emmanuel Okorie. All right, just hold on. All right, you're welcome back. We're looking at the legal implications of the freezing by the EFCC of the personal bank account of a sitting governor in the person of Ayodele Fayose. And our guest in the studio is Emmanuel Okorie, who is a lawyer. He's been looking at this for us. But for now, let's examine a few cases related to this. Now, the case of Fayose against Tinubu in 1999 over alleged certificate forgery, where the Supreme Court held that a sitting governor can be investigated while in office. The late Gani Fayose had challenged the academic qualifications that Tinubu presented to INEC.
Fayose was told by both the High Court and the Appeal Court that Tinubu, as then sitting governor, cannot be tried as he enjoys immunity from prosecution. Fayose then headed to the Supreme Court, and the Apex Court ruled that though Tinubu enjoys immunity from prosecution, he can be investigated by police over the allegation and tried after his tenure.
Now let's look at other cases. A federal high court judge in Abuja ruled in a fundamental rights enforcement suit in the case of former governor Muritala Nyako's son, Senator Abdulaziz Nyako, where the court reprimanded the anti-graft agency for carrying out actions outside its statutory powers and held that the EFCC lacks the power to freeze Nyako's bank accounts without obtaining court order, and consequently ordered the commission to pay the sum of 12.5 million naira to Abdulaziz Nyako to serve as a warning. Now, back to you, our guest in the studio, Emmanuel. How different is the Nyako case from this Fayose case?
Well, the difference here may be the obtaining or the non-obtaining of an order. Now, if in the earlier case that you have mentioned, the EFCC did not obtain an order, then the court will be right to say, you cannot do this.
Now, that's the ruling.
Yes.
They did not
that's
obtain.
The
that was the ruling,
yes.
so
that's
they
the
did
point.
not obtain.
And that's why I had said that I expect, knowing fully well what they had gone through in the past, on this, that's why I said that it is expected, naturally. You see, while I listened to the governor say that no order, or Michael Zekoma say no order was obtained to freeze the account of sitting governor Fayose, I said I would be very surprised if the EFCC will make the same mistake again. Really, because I expect when this matter comes up in the Federal High Court in Ekiti on Monday, I will expect that the EFCC will exhibit to their response to the application. Because what the court had done so far is to say, oh, we're not going to hear you on this way. Put the other parties on notice. Put the EFCC on notice, put Zenith on notice, let them come and give proof as to what they have done. I would not be surprised if they are not able to provide court order as as an annexure to their counter. I would not be surprised if the court goes the same way. If the court goes ahead and said, oh no, you could not have done this, for this reason you pay damages. That will also mean that Zenith Bank will also be ordered to defreeze the account.
Okay, but this particular case we're referring to happened to Murtala Nyako's son, not Nyako
himself.
No, certainly Nyako's son does not enjoy immunity.
Absolutely
is not definitely not a sitting governor for the purpose. Was not a sitting governor for the purpose. So, but of course, it will depend on what facts they have furnished. It will mean, for instance, that the court. I will also be surprised if the EFCC did not appeal such a judgment, because you will have a judgment that will say that the Nyako's son, by implication, has enjoyed immunity, and you let the case sit. And that's why I said developing, and deepening our democracy.
No, but beyond the immunity case, even if you go back to EFCC Act, for such action, either you enjoy immunity or not, it has to be through an ex parte motion. That means they must get court order, either you have immunity or not.
That's a prerequisite. There's no doubt about that.
Okay, so yeah, I'm just trying to refer you to the point you were making about it. So either it's Nyako's son or Nyako's brother. If you need to confiscate, if you need to freeze the account, then there must be a court order.
There must be a court order at all times, because anything that negates obtaining a court order will mean that you're doing self-help.
So why would the EFCC, knowing that, this is the standard, fail, and allow for this loophole?
Sometimes human errors, sometimes overzealousness.
Are they too excited to, just...
Sometimes overzealousness. If you have, for instance, somebody who sociologically does not believe as much as me and you do in the, human rights, for instance, who actually is overzealous over his jobs, and you'll find that it does happen every now and then. That's why, of course, the courts are there. And that's why, of course, the courts are actually supposed to check some of these excesses.
Now, even just recently, EFCC was fined to pay some millions of naira to a particular person for wrongful detention. So you cannot really absorb EFCC of such overzealousness in this case as well. Can you?
In this case, assuming, and because I have not authoritatively seen, I have not seen, and I cannot speak authoritatively that the EFCC,
whether they do have a court order or not.
That's why I'm saying that it will be very disappointing
if they
having passed through this route. It will be very disappointing if the EFCC will still be found or caught in this kind of mistake. Okay,
let's go even deeper now. Legal icon Femi Falana has also reacted to the issue. Let's listen to what he has to say.
The governor of my state collected 1.2 billion naira for his election from public funds in Abuja, and in the process also used soldiers to rig the election. As far as I'm concerned, what happened in Ekiti was a coup, and so you cannot plead immunity. But the governor then did something yesterday, and I've reacted this morning. He said no, it was because they found the money in Zenith Bank. The governor recklessly said it was Zenith Bank that provided the money. Even though Zenith Bank has dismissed the allegation, but assuming without conceding that the governor is right, that admission, that confessional statement, has only confirmed that your election was illegally funded, under Section 90 of the Electoral Act, there is adequate provision for funding elections, and no corporate body can donate more than 1 million. So if you are saying 1.2 billion was given to you by a bank, you have offended the Electoral Act, the BOFIA, the Money Laundering Act, because you also agreed that the money was ferried from Abuja to Akure. Money laundering, cash of 1.2 billion. So I'm saying that means the bank management, if you are right, and the governor are liable to be prosecuted for money laundering and criminal diversion of public funds.
Okay, now this further complicates this issue for Fayose, doesn't it? And indeed, the bank involved.
Course, yeah, except of course to say that there's a distinction between this, the legality of freezing his account and the issue of election funding. Because, you know, we had the INEC official here who dealt with that, the Electoral Act, of course, that is, so there could be quite a number of charges here, but there's a distinction, so we don't mix them up, really.
The distinction is clear. What Femi Falana has said, SAN has said, is quite incisive, but it's as incisive as it's true, because our law prohibits a bank or any other company, for instance, from funding any electionary campaign. And so if indeed the allegations brought against Zenith Bank is true, and indeed, you know, I will actually advocate that it broadens the spectrum of investigation. This needs to be looked into. First, Zenith Bank was prompt. They were quick at denying the allegations, and I'm not surprised, really, because they know as of right that it is not part of their responsibility to actually fund elections. So when a governor actually comes out in the open and says my election was funded by a bank, he's not just committing himself, he's also committing the bank that is an issue. You know, so going back to your question, yes, it's clear. The issue here means that, yes, there's a freezing, and then there's this other leg of who funded your election, both of which need investigation.
And then, of course, the money laundering aspect, which Mr. Falana
Obviously
also raised there. Now, all of this is happening because of this present government's anti-corruption war. Now, when you have an EFCC that does not do a thorough job, that leaves these loopholes, you know, for the alleged, you know, criminal or offender, you know, to actually get away, where does that leave the whole anti-corruption war at the end of the day?
You see, this government, I have to say this guardedly, this government will be perceived or is seen as we speak today to have a one agenda, and that one agenda is corruption. If you ask me, at the end of the next 3 years, if this government does not achieve anything other than corruption, I can bet you Nigerians will not give them a pass mark. We have other issues that are bothering Nigerians. A lot of people are hungry, a lot of people are losing their jobs, there's no electricity, you know, there are no infrastructures, you know, here and there. And so we're expecting much more than this. So if a government actually sets out to say, oh, corruption today, and then in some quarters it is perceived to be against certain people, only a certain, you know, set and order. So when you have this, you will expect that the government itself should do its work. It's not enough, for instance, to say, we are doing investigation. It's not enough to say, oh, okay, it's so person. As a matter of fact, the way and manner the national cake, the treasury, had actually been looted in the past couple of years, from what we see in the social media, from what we see in the news, from, you know, the kind of accounts that we're seeing, it is actually very disturbing. But then again, it is not enough to actually say, Nigeria, wait, we're doing recovery.
According to INEC, INEC says it's actually investigating because, you know, if you follow the Electoral Act, section 92 about 97, which the funding actually came under, it is the job of INEC to find this out. So it's not even if Fayose is found culpable, it's not only Fayose. There are a lot of politicians out there who might have run foul of this particular section of the Electoral Act. And what is INEC doing? According to INEC, a PRO that we had, they are conducting investigation for the 2015 election in 2016. This is June, so they are still conducting investigation about it. So it goes even beyond the EFCC. Quite a number of government institutions might just be indicted in this matter.
That's what it means. That's what it means, and that's why you have a government. Because what it will mean is that all of these organs, all of these parastatals, all of these government agencies are supposed to be working as a team, really. Because if you have INEC and who certainly have people who are run foul of the rules, such people should be reported to the police for investigation. And when these investigations are carried out, naturally the people should be subjected to consequences of offenses, crimes committed.
Indeed, Emmanuel